Hello, everyone, and thank you for tuning in to our Ask the Experts via Zoom. Today, we are here with two very prestigious attorneys that are going to discuss two very important topics that are current in these different and difficult times. They are from the law firm of Nehmad, Perillo, Davis, and Goldstein, and we have Eric Goldstein here with us and Michael Lario. So, gentlemen, we are, just thrilled to have you here, and we know you're both extremely knowledgeable attorneys in our community. And we wanted to start with Eric first on the matter of contracts and cancellation of contracts and force majeure, if I'm pronouncing correctly.
You are.
Go ahead, Eric, if you want to share.
Sure. Thanks, Mary Lou, and thank you for having us. Most importantly, we're really happy to be here, but we'd rather not be here. We'd rather be doing this in person. We'd rather have all of us together, but under the current crisis, this is the new normal. And we're faced with new challenges every day, which we never thought we'd have to deal with. From social distancing to Zoom meetings and court filings now, everything's being done online, and court procedures now, everything's being done online. So we're, at least for the foreseeable future, dealing with this as best as we can. I think everyone's doing that. I'm sure the challenges are being met in your industry and real estate on a daily basis. So it's our honor to be here, and hopefully we can add something to what you're doing and give people advice or some information generally to kind of help them through. Because, one thing, if there's a positive to what we're dealing with now, is that we're all in this together. We're all situated in the same way. This isn't a thing that affects New Jersey or America. It's the world. And we're all under certain restrictions now, which none of us thought we would ever be under. And that really plays into this issue of force majeure, which is actually a French word, which means superior force. And generally, force majeure is a clause that's written into a contract just in case. For example, if two parties have a contract, one to deliver an item to someone else, there's sometimes a just in case clause. For example, if a war breaks out, or if there's an earthquake, or some other amount of social unrest, force majeure allows one party to the agreement to excuse themselves from performance. A great example would be a war. I mean, it's a terrible thing to think about, but it is the most fitting example. If one party has a contract to do something for another, and that performance is somehow prevented from happening due to an act of war, clearly the deal can't go forward, and the party who wishes to excuse itself will be excused. Another example is some other unforeseeable act of God, an earthquake. Unfortunately, coronavirus. Nobody could have possibly foreseen that in 2020, society would be trapped in its house, the stock market would be down 30% or more up and down each day, and we'd be dealing with a deadly virus where if people come in contact with each other, we're generally now wearing masks and we're taking precautions, which even a couple months ago, nobody could have possibly predicted this would happen. So when we talk about force majeure in the context of coronavirus, what we have are a number of issues, but really the idea that no one today is in the same position they were in a month or more ago. And as it relates to real estate, there are people who are under contract presently to buy or sell real estate or lease real estate, and we'll get to that in a second, who couldn't have foreseen the issues that we're dealing with. Most notably, most people on April 14th, on the date that we're filming this, are not in the same economic situation they were in a month ago. Economics by itself is not a reason that force majeure would allow someone out of a contract. But before we even get there, most contracts don't have a force majeure clause written into it. And I'm not sure with regard to the Board of Realtors how their contracts will be prepared in the future. But presently, force majeure is not generally something you would see in a residential real estate contract to buy or sell property. So we talk about whether or not you are relieved of your performance because of something that happened with coronavirus, generally the answer is no. You can't just say, coronavirus happened, I'm a buyer, I want out of this deal, because for the most part, the reason people would do that is they would think the property they agreed to buy for a dollar figure 2 months ago is not worth what they thought it was worth at the time. So if you were under contract on March 1st to buy a luxury condominium for $800,000, presumably on April 14th, that property might not be worth the same dollar figure. People might try to shoehorn in this idea of force majeure to try not to buy it because they feel like the numbers have gone down. Very important, economics alone is not a reason to invoke force majeure. However, you may have a situation where someone is under a lease agreement to rent a place for the summer at the shore who lives out of the area. Well, presently, most shore towns have prohibited by ordinance short-term rentals. So now you've got what we call impossibility of performance or impracticability of performance, that if you live in we'll call it a suburb of Philadelphia, and someone rented back in March 1st, a condominium at the shore. That individual right now is prohibited from using it because the short-term rentals have been banned by most shore towns. So does that person have a right to get their money back? Does that person have a right not to use the building because obviously the building is going to prohibit people from coming into it based upon coronavirus? Social distancing doesn't allow the potential tenant to rent the place as they thought they would. So in that situation, the short-term rental ban remains in place and the social distancing guidelines remain in place, it would seem more likely than not that someone who had a rental for the summer, if all these guidelines continue, would be able to get out of that agreement because they can't use the unit as they thought they would be able to, okay? And as a landlord, that's very frustrating because you're going to lose money. You're potentially not going to have any tenants there at all. But if your tenant can't get there, the purpose for which they were going to use it is frustrated. And that really isn't force majeure by itself, but it falls under the category of frustration of purpose, either impracticability of performance or impossibility of performance. And Mike, I know you've done some substantial research in this regard, so I'll turn it over to you for a little bit to talk about what other items kind of play into impracticability of purpose, especially at the shore with the boardwalk, the beaches, and the casinos.
Sure. Well, I think it's two concepts really at play here that you mentioned. It's frustration of purpose and impossibility. Obviously, if the ban on rentals continues for the summer, then it will be impossible for those rentals to take place. I think one alternative situation, I know in a lot of shore towns they've started banning boardwalk, gatherings on the beaches, etc. The question is then going to be the purpose of these contracts, to use the beach, to use the boardwalk. They're frustrated. How will that allow renters then to try to get out of those lease agreements? And that's something that's going to be a very fact-intensive analysis that's going to have to take place, where they look and say, again, it's not impossible for them to use this condominium rental as the example Eric provided, but the purpose of that rental, are they going to be able to get what they initially bargained for with it? And that's something that it's really going to come down to individual tenants and landlords to try to determine how to work out these agreements. And I think that's something that speaks both to these common law principles that Eric mentioned, where we're dealing with impossibility or impracticability, frustration of purpose. It runs alongside that and the force majeure concept, which is a contractual provision usually. They're not exclusive, they can exist simultaneously. But I think you have to look at how there's a frustration of the purpose of the contract, whether it's impossible or impractical.
And I've seen a bit of an issue with some clients that specifically have rented here for the summer to go to a high rise and to go to the pool deck on the high rise. They want to go to the high rise, go down to the pool, sun themselves, use the pool. If we're still social distancing in the summer and the pool decks are closed, as they are now all over the country, most notably in Florida, where people have been going for vacation. The public pools are closed, and you can't be within a certain number of feet of anyone else on the sun deck. So recently had a couple of inquiries from people who are renting for the summer, and they're worried that if they get to their shore high-rise rental, they won't be able to use the pool. They won't be able to use the boardwalk. The beaches could be closed, and now we've seen beaches that are open, but for foot traffic only. So if someone can't have a picnic on the beach, and if they can't lay on the beach, but they're only allowed to walk on the beach, is their purpose for coming being the enjoyment of a pool, being able to sun themselves and to sit on the beach under an umbrella? Is that purpose now frustrated because the only use they have is no boardwalk, potentially no casinos, although hopefully they open as quickly as possible, no use of the sun deck, no use of the public pool, but they're allowed to walk from point A to point B on the beach if they're 5 or more feet away from someone else? To me, that would indicate a frustration of purpose, the purpose of which is enjoyment and relaxing in an area, but you're not able to do so if you're only permitted to be on the beach while walking. What do you think about that, Mike?
Yeah, I'd agree with you, and I think that's going to be something. I think right now, because obviously the rentals are closed for the foreseeable future, it's a little easier of a determination. I think once that ban on short-term rentals is relaxed, I think then you're going to have these issues that you're talking about where it's really going to be a fact-sensitive analysis where legally they can still rent these condominiums or properties, and the issue is going to be trying to determine what the purpose was for renting it. And that again, it's a very fact-sensitive analysis that's going to have to take place between the landlord and the tenant.
And one of the things we're also seeing is that people who are under contract to purchase are looking to get out of the deals because they feel as if the property is worth less today than it was before. And I think it's very important to note that, and we're telling all of our clients this, if you are under contract and you haven't lost your job and you haven't contracted coronavirus and you're not otherwise affected by this, except for the fact that you have less money today than you had on March 1st, for example, you can't get out of the agreement. This isn't a free pass for people to try to avoid closing on their properties. And it's fairly important because there's this mentality that it's the Wild West now. All bets are off. We've got coronavirus, so everyone should be allowed to do whatever they want to do, which is not correct. We still live under a certain social contract, and we're still bound by our legal contracts to do the right thing. If you are a worker who has lost his or her job and you are using your money to buy a piece of property, it's likely a court at some future date will allow you out of the contract now. You won't be judged harshly if you're not able to get a mortgage because you're no longer employed. And in those cases, if people were looking to get out of contracts, it's more likely they'd be able to do so. We haven't seen that much of people who legitimately lost work, lost the ability to buy their properties. And Mary Lou, I would assume in your business, you have a lot of high-end, high net worth buyers. They're not affected so much that they can't close on properties. I think it's more the person who was marginal, who needed a mortgage, who was counting on some additional amount of deposit to come through by way of their weekly paycheck that would be affected by this a little bit more. Is that correct?
Absolutely. I don't think we've had one transaction cancel in regarding a sale. The majority of the questions we're getting, and we're working on them, individually, are summer rentals primarily and yearly rentals. But as far as contracts of sale, we've had just one encounter with someone who lost their job, but then they got another job to try to work through it. So we haven't had an impact as far as an actual sales transaction is concerned.
That sounds about right. And then the other thing is, respectfully, most people know when they're doing the right thing and they're doing the wrong thing. If you're under contract on March 1st and you believe the right thing is to buy that piece of property, then you should go through with the deal if you can. The fact that you're using coronavirus possibly to get out of your contractual obligations is simply not morally or ethically the right thing to do. Again, we live by a social contract as much as our legal contracts. And we've seen a fair number of people try to avoid doing the right thing using the COVID-19 outbreak as a big problem. So if you're in a financial hardship and your mortgage company cancels an agreement, cancels their commitment to you because you're not able to make the payments anymore, that's a legitimate way or a legitimate reason perhaps not to go through with your transaction. And the example Mike and I were talking about earlier, if the economy was great and there was no coronavirus, and you're under contract to buy a piece of property, say for $1 million, and between the time you go under contract and the time of closing, the market increases by some miracle 20%. The seller doesn't have the right to ask for more money because the seller would be entitled to an additional amount because the seller would think that the house or other condominium, whatever the property was worth more. Likewise, if the market goes down, the buyer doesn't have a right to ask for a reduction in price because they think it's worth less. If you can afford it and you are reasonably under the same situation you were in and not otherwise sick from coronavirus or something else happened to you and your family from the date this all started, our advice is you should continue to comply with your contractual obligation. If you've lost your job and your mortgage company cancels their commitment to give you financing, then clearly you have a right to get out of the deal. The bigger issue is, because this is so new, and because we're literally in the middle of the greatest health crisis and unfortunately one of the worst economies we've seen in a very long time, there aren't any court cases or other guidance from the higher ups that would allow us to go forward and say, we're relying on this legal precedent. Right now, we're kind of flying blind when it comes to what to do and what not to do with how the courts will judge us later. As I said before, if you're doing the right thing and you're not looking to use coronavirus as a way to avoid your obligation, it's likely the courts will not judge you harshly in the future. If you're trying to shoehorn in some way to get out of your obligation and otherwise falsely blaming it on the COVID-19 problem, I think you will be judged harshly because people and at the judicial level, and Mike can speak to this because he was a judicial law clerk and worked for some fairly prestigious judges, they're not going to allow people to avoid their obligations just because coronavirus exists. What do you think about that, Mike?
Yeah, I think one of the big things that I take away from this, to build off what you're saying, is if someone approaches this and uses coronaviruses to their advantage to try to get out of a contract for purely economic reasons with none of the factors that you mentioned, the circumstances, I think what they're going to find is the judges, the jurors that they meet in a dispute, they're all going to have their own individual losses. This is something that has affected every single member of the community in some way or another, and some pretty harshly, loss of jobs, income, etc. So I think when a dispute arises, if it were to go to the judiciary, you're going to find that people are all going to have loss. And I think they may be less receptive to a potential dispute because of that, because they've all been having to deal with their own level of loss, both socially, economically, etc. So I think that's going to be a concern to keep in mind.
As I said before, we're all in this together. It's affecting all of us, perhaps not equally, but certainly we see how badly the frontline people are being hit by this. And, we're all very thankful that the doctors and the police and the hospital workers and the restaurant workers, they're all helping to serve us. And they all have losses of their own because they've dealt with this at a much, much more traumatic level. They're watching people literally die. With that background, for someone to say, I don't want to close on a piece of property because I don't like that the price has gone down, in my opinion, 10%, and I have no other impact on my life from coronavirus, those people, I do believe, will probably lose if cases that they're involved with go to court. We don't have a crystal ball, so we can't tell for sure. But if you look at, Mike, what you just said, the world is affected by this in an awful way. For someone to try to use it as an excuse not to go through with their obligations is equally awful. We're all doing the best we can under extraordinarily stressful circumstances. And whether it's a real estate deal or just, the social contract we have, walking down the street, trying to, maybe be a little nicer to people, and maybe trying to, even though we have to socially distance, be kind and to, again, do the right thing. The people who don't and who are using some premise to not do the right thing, and that premise being the current economic and social situation, I hope no one would do that. But I think, as an aside, I've seen over the course of the past 2 weeks more scam emails telling me that my check was ready and the government has all my money. All I have to do is give them my bank account and click on this link. Clearly, that's a scam. But the scammers, they're out ahead of us in generally every aspect of what goes on. And they were the first ones to jump on the payroll protection program and say, your money's here. If you want to click on this link and give us your account, we'll wire it to you. The best and the worst come out in times of crisis. And I think you'll separate the best from the worst by, again, trying to do the right thing. The people who are looking to take advantage of others, and unfortunately, it's generally the sick and the elderly, because they're the most easy to scam. They're going to do that no matter what. And they're seeing this as an opportunity to try to take advantage. So the goal that we've got is to do as much good as we can do, not to use coronavirus as a way to try to get out of an obligation or a commitment we've made, and more importantly, to follow through on our commitments. Because, Mary Lou, I can't speak for the real estate industry, but I would presume that your guidance is the market, both the stock market and the real estate market, are cyclical, and it might be down for a little bit, but eventually it'll be back and probably stronger than ever.
Absolutely. Unfortunately, we have to work through these times, and we have to be reasonable and fair. And from a real estate professional perspective, all we can do is talk to the clients, make recommendations and ask them to be reasonable. If, there's a point that they're not understanding, frustrations with purpose and, the guidelines, and we're going to have to divert to attorneys, because these are unprecedented times. And, we want to work fairly with people. We don't want anyone to be put at a disadvantage. But I think these are times where we still can move forward and purchase properties and have a great summer. But, it's just going to be a little different.
And from my perspective, personally, I'm spending a lot more time in and around my house. It gives me the desire to take on these little projects that I hadn't done for a while, and making my house really where we're going to spend more time in the future. If travel's cut back a little bit, and if going to sporting events or concerts is somehow curtailed, I think people will want to be in their homes, making their homes nicer, making their second homes someplace that, instead of taking a vacation to Europe or to Florida, they're going to say, we're going to use our money as much as we can put towards our second home and make the beach our vacation. At some point, the beaches and the boardwalks and the casinos will open up again. And there'll be a little bit of a hesitancy for people to embrace it right away. But like you said, things are cyclical, and we'll get to a point where it's 2020, call it August. And August of 2020 hopefully looks a lot like August of 2019. And I think people will start being nicer to each other. And you'll see more people who have been through this together coming together and wanting to spend more time together, which means real estate will be an investment that beats perhaps the stock market, that beats other places you can put your money, because it's, we always talk about this legally, real estate is tangible. The dirt that the house is built on, you'll always have. the house may come and go, you may rebuild, or you may have to do renovations, but it's something you can put your finger on versus, the stocks that you own generally are intangible. It's a piece of paper. You don't have your stock certificates. You have your statements every month, but you don't own anything other than a percentage of a company. So, when clients are saying, should I stay in this real estate deal? We're telling them generally yes, because it's real. It's something that you'll always have. Perhaps the price will go up or down, but it won't disappear. The land will no longer exist. I don't think that's ever happened where something that existed on day one doesn't exist later. What it looks like might change, but you could invest in a company and that company could go out of business, and your 5,000 shares of XYZ company are worth nothing, and you have nothing to show for it. Your investment in a piece of property is generally forever.
That's totally true. And we spoke this morning at our staff meeting that, my prediction is that people will want to improve their homes and buy at the shore, because that's where they make their most precious memories. And, that's going on forever. So, we're hoping that will be a safe haven and a comfort zone for many, and they'll want to continue with real estate investments.
That's
Since
great.
we're talking about investments and values, do you want to talk a little bit about tax appeals?
Sure. So, Mike, why don't you start on tax appeals? And, we've been back and forth about what we're doing for 2020 versus where we're going to go for 21. But I'll let Mike start on this one, and then I'll pick it up.
Sure. I think the big piece of information that you want to get across is the deadline for tax appeals has been extended to May 1st or 30 days following the end of the declaration of emergency passed by the governor. So it's looking very likely that the date that all tax appeals must be filed by is going to be some point in the future that really is yet to be determined. It's going to be past the the May 1st deadline. So right now we're in the process. We're recommending all clients take a look at the assessments for their property. This extra time should be used to see whether this would your property would benefit from a tax appeal for 2020. And going forward, we expect there to be a pretty large increase in the filing of tax appeals. And I think, Eric, you can speak to the reasons behind that.
So one of the issues, and right now people are calling with regard to their property taxes because they believe their property is worth less now than it was when it was assessed, which is likely true. The potential issue is, however, for tax appeal purposes legally, the government looks at the value of the property as of October 1st, the prior year. So if you file a tax appeal this year, whatever that is, May or June of 2020, the valuation date is October 1st of 2019. On October 1st of 2019, it's likely everybody's property was worth more than it is now. So the advice we're giving clients is if you really believe your property is overassessed, then you should certainly look at your assessment and file an appeal. For 2021, however, I think everyone should file an appeal because as of October 1st of 2020, which will be the valuation date for the following tax appeal year, it's likely the numbers are going to be lower. So if your tax assessment as of October 1st or the value of the property should be lower, and when you get your tax card in February of the following year is higher, many, many people are going to file the tax appeal for next year. If you are not one of them and everybody else gets their tax assessment lowered and you don't appeal, then you're remaining at the same level you were the prior year. What generally happens in years when there are numerous tax appeals, the municipalities will lower a lot of assessments, but they will raise the tax rate. So good example is if your tax assessment is $1 million and your rate in whatever town you're in is 3%, your taxes will be $30,000 a year. If your assessment goes down, give you some extreme number, to $800,000, then your taxes are 800 times the 3% or $24,000. For the people who don't appeal, what's going to happen is the tax rate will ultimately likely go up. and now you're being taxed at a higher rate and the same assessment that you had from the prior year. We're advising all of our clients to appeal so that you have a lower assessment in the event the municipality does what it probably will do, which is raise the tax rate. Whenever a tax rate increase is likely to occur, you should appeal just to get the number down as low as possible. The person who does it incorrectly is the one who doesn't appeal. When the rate goes up, now they're paying a higher rate on a higher assessment. So they're getting a double dip by the government to take their money. And that's what we're looking to tell clients to avoid no matter what. So although this year is likely going to be a fair year for appeals, our prediction is 2021 will be an excellent year. So keep an eye on all of your tax assessments. And if you own a commercial property, the most important thing to do this year is to fill out and send back your Chapter 91 income and expense reports. If you don't do that, the government, the municipality you file the appeal in, can move to have your tax appeal dismissed for failure to comply with what's called Chapter 91, which is a form that's sent out every year by the municipality to determine the value of your income and also for you to show your expenses on commercial properties. Fill that out this year, no matter what.
Excellent information. Gentlemen, we had two questions posed to us when we mentioned that we were going to have you as our experts today. And the question is as follows. I have a situation with my client that has a rental agreement at the Ocean Club. The yearly lease was executed March 3rd of 2020 prior to the stay-at-home orders. The start date of the lease is April 1st, 2020. This is a secondary residence for the tenant. As such, she is respecting the stay-at-home orders issued by her governor in Pennsylvania and our governor in New Jersey and has not occupied the unit yet. Can the landlord collect the rental payment for a space she is unable to occupy due to her stay-at-home orders? The tenant is not interested in extending the lease on the back end of the agreement.
So generally the answer to that question is no. The landlord can't collect rent if the rental unit isn't being used. And this goes to what Mike and I discussed earlier, which is the frustration of purpose. But it's also possibly impossibility of performance. If she's abiding by the governmental order from the president, the governor of New Jersey, and the governor of Pennsylvania not to travel and to shelter in place and quarantine, then it doesn't make sense that she should pay rent for something which she cannot use. The landlord would probably like her to tack on the time at the end so he or she could collect as much money as possible. But if the lease is for a year and your client can't use it for, say, 6 months due to the issues we've just discussed, the landlord would not be able to collect rent because the tenant isn't getting the benefit of the bargain.
Yeah, I would add to that just briefly that I think likely, and I obviously haven't looked at the contract, there's probably not a force majeure provision in that lease agreement. However, the doctrines that you mentioned, these common law doctrines, they can still apply even absent that provision. So I want people, if they look and they don't see that force majeure provision, they can still seek relief through the doctrine of impracticability, impossibility, that there's still available relief to them absent that specific provision.
That's a good point.
Excellent. I wonder if we should add addendums with that language going forward.
We are advising in all real estate contracts, residential and commercial, to have some accommodation that, not that you can get out of it if you change your mind, but if you're affected by a loss of employment or if you get sick, that you may have the ability to not necessarily get out of the agreement, but to extend your performance so that no one's forced into a worse situation. And that would be if someone were to get sick and not be able to perform because they're in the hospital. They'd have to be able to get out of it. It just makes common sense.
And suppose we have a summer tenancy that is scheduled to make a payment, and right now the cities are not accepting any certificate of occupancy applications until May 15th. How do you suggest we proceed when we have a tenancy most likely who hasn't been able to move forward and is not sure they're going to be able to use the unit for the summer, and their second payment is due?
Well, unfortunately, this is probably going to become a fairly common issue as we get closer to the summer. But if a tenant is not able to use a place now, and you can't get a certificate of occupancy because short-term rentals are now banned, this really falls under what Mike discussed earlier, being the impossibility and impracticability of purpose. We would not advise a tenant to pay a landlord for something which may not be usable at all during the summer. I'll let Mike take it from here.
Yeah, I think the suggestion would be not to put the money forward at this time, just given that there's so much uncertainty with whether they will be able to occupy, and as Eric said, the impossibility of that summer rental. I think that the bigger idea here is the flexibility on the part of the landlord to try to work with the tenant. There's not going to be that long line of interested parties here who are looking to enter into these agreements for these short-term rentals. I mean, no one knows what the next week, the next month is going to bring. So to expect someone to put that money up now, it's unrealistic, and it kind of ignores the reality of the situation that we find ourselves in. It's very different than a situation, normal summers, where you could find someone to rent that piece of property in August or in July. That's not the case now. So what we're recommending is really for the landlords and the tenants to try to work with each other to come to some solution here. And it's going to take some flexibility likely on both parts, but it's certainly not business as usual here. And I think for the landlord to try to operate in that way, again, it ignores the realities of the world that we're in.
And one of the things which is an unfortunate reality, I want to follow up on what Mike said, the court system is going to move cases through extraordinarily slow for the next few months. And if someone is getting a payment of a security deposit, a landlord is taking a deposit, the landlord now has that money. And getting that money back is going to be so much more difficult based on what we're seeing with the delays in the court system. It used to be if someone had money and a plaintiff was attempting to get that back, you could file a complaint and you'd have a fairly quick turnaround time to get to a court, whether it was in the special civil part or small claims, or even in the law division, which handles the claims of higher amounts. If you're a defendant today and you owe somebody money, you're likely able to kick the can for a very long time and not return that money, because the court system has done a great job adapting to the coronavirus crisis. But everything is basically on hold. There have been numerous orders from the New Jersey Supreme Court saying answers don't have to be filed right away. Service of process of complaints now takes a longer period of time because it's hard for the sheriff to go and physically search somebody because you can't get close to somebody due to coronavirus. So the bigger issue, which is the practical issue, if someone's going to pay a landlord for something they may not be able to use at all, the question becomes, how likely is it that the landlord will give the money back if coronavirus and the COVID-19 crisis continues? Because we've all had cases where one party has the money that the other party wants. And the party that has the money basically says, I've got it, you come get it, or make someone tell me to give it back. And those situations are very unfortunate, but there'll be more of them now. Landlords who don't want to give the money back. Sellers who have had buyers walk away, not wanting to sign releases so the buyer can get their deposit money back. That's going to become a much more common topic that we deal with legally. And the problem is filing those complaints to get the money back will now jam everybody up an enormous amount of time. But the defendants who are holding the money will be the ones who ultimately benefit, because it'll take so much longer for the court to get to them.
Yes, absolutely. And my last question, this is the scenario. The property is under contract and the mortgage commitment was obtained. the mortgage company stopped funding jumbo loans, can the buyer rely on force majeure or an act of God or as an out for the contract due to COVID-19? Or can the seller keep the deposit if the buyer defaults?
Mike, you want to take this?
I think the first would be you'd have to look at the contract to see if there are any force majeure provisions in there. Absent there being a specific reference to force majeure in the contractual, in the contract, I think the next thing is you would look to these common law principles we discussed. It sounds like the commitment was provided. So I think you'd have to try to understand better what the reasoning is for seeking to get out of the contract. If it's purely economical, then I think there's less of an argument, as we discussed, for justifying the reason out. I mean, unless they can show some additional loss of income, et cetera, I think that's really going to be the big test is what's the reason here that they're seeking to get out of this contract.
And the other thing which becomes a problem is a lot of banks will probably change their lending requirements because they're going to be audited at some point by federal government. And banks were having a much easier time lending money when the economy was strong. If a bank decides to stop writing a specific type of mortgage, then potentially it wouldn't be an item of default because the buyer would be prevented from getting money from its lender. The seller couldn't really complain too much as long as the buyer acted in good faith. Unfortunately, we've all had cases where a buyer will intentionally sandbag their own mortgage application. They'll tell the bank, I'm about to lose my job, I'm sick. They'll say anything to get out of getting the mortgage so they can cancel a contract for the mortgage contingency. But if everybody's acting in good faith and the bank simply decides to stop writing a specific type of mortgage, I think that might be a very specific instance. I'm not sure how many banks are going to stop writing, but if they do, then if everybody did on the buyer side what they were supposed to do and they acted in good faith, it would be hard to imagine a court someday saying, you breached the agreement, because they didn't do anything wrong. The buyer was proceeding as best they could. But if their lender and other lenders decided not to write a specific type of loan, then how would they otherwise come up with the money?
Exactly. Well, we're definitely going to have to reset and revisit all these scenarios as they unravel. And our session today has been super informative. We greatly appreciate your expertise and your knowledge, just stellar. And going forward, if our clientele reaches out, we certainly want to recommend Nehmad, Perillo, Davis, and Goldstein as experts in these two fields. So thank you again, and we'll look forward to working with you in the future.
Thank you, Mary Lou, for organizing this, and hopefully we're all distanced from each other, and we'll be all right. I think in the end, the people who make it out of this crisis will make it out stronger and kinder towards each other, and the people who are angry now and bitter and trying to get a leg up on each other, it's not going to work because society will judge those people in a poor manner. There's no right or wrong with coronavirus because we don't know what to do, but there is right or wrong when it comes to moral and ethical ways to treat each other. So we're going to try to do the right thing, and hopefully we come out as a legitimately kinder and gentler nation.
Yeah, we'll have to find the silver lining.
There has to be.
Well, it's great to see both of you guys via Zoom today.
Thanks.
Thank you, Mary Lou.
Thanks again.
Thanks for having us.